Okay. So, year 1300, the second writ of trespass on the case is created. And jumping ahead to the 1870s, the Judicature Act abolishes the writ system in England and establishes a system where if the facts of the case were justified, then relief from the courts could be granted. However, some remnants of the writ system still remain today. And noting that a tort comes from the writ of trespass, or the writ of trespass on the case, does have certain implications. So we start to see the division of tort law from other aspects of law. In the 1890s, lawyers began to speak of tort as a distinct branch of law. There are competing theories of tort. So some say that tort is a patchwork of distinct causes and actions, each protecting different interests and based on separate principles of liability. There is a finite set of independent rules, and courts are not free to recognize new heads of liability. So the courts can't just create new causes of action. So the unifying principle of torts is that all harms are tortious unless they can be justified, and this is kind of competing with the torts are a patchwork of distinct causes and actions theory. In the 1920s and 30s, the issue of negligence came up. And in 1932, it was recognized that there is a legal duty of care giving rise to tort actions of negligence. So the debate continues today, and sometimes courts will decide to narrow the duty of care, thus decreasing the liability of the person involved in that activity, or broaden the duty of care, thus increasing the liability of the person involved in that activity. Talking specifically about the writ of trespass, you were forced to plead that there was force even if there wasn't. And all that matters now, I guess, is that harm was done. It could have been negligent or accidental. So I guess this is the history of the writ of trespass. So there weren't any detailed records, and so no precedents were kept. Now the writ of trespass has led to battery, trespass, assault, false imprisonment. These are largely unchanged, and they involve direct injury to the person. The writ of trespass was not available when the plaintiff put their goods voluntarily in the hands of another, or if the injury was non-violent or indirect. And because of this, they developed actions on the case or trespass on the case. So these are special circumstances. There's more of a fault element in actions on the case. So it's for the defendant to raise a justification as to why they did what they did. And examples of it are malicious prosecution, intentional infliction with nervous shock, and these involve indirect interference with the person. Volition and intent. In order to have an intentional tort, there must be intent, so the desire to bring about a specific result, and volition, action directed by the conscious mind. There are a few different types of intent. First, there's actual intent, so desire to bring about the specific results or consequences. Now, even if you do have intent, it's possible that you may not be liable. So the battery pushing a child out of the way in an oncoming car, yes, it's definitely battery, but you may not be liable. And you have to prove intention to have an intentional tort. Now, if you touch someone, then that is the tort of battery. You don't have to prove that the person intended to do all the damage that they did from touching you, just that they intended to interfere with you. If they trip on their shoelace and accidentally headbutt you, there was no intention there. But if they grab you by the shirt, there's intentional intention there. So yeah, they're responsible for whatever happens after that. So the other kinds of intent are imputed intent, so, or constructed intent, and your intention is constructed from your intention to harm someone else if a third party is injured. Classic example is the throwing a bomb. So you're liable for damages that were substantially certain to result from your actions. I guess you could also look at if you drove your car into a store to hit someone who was coming out and you accidentally hit 3 or 4 other people. Your intention would be constructed from your original intent or imputed from your original intent. You can also have transferred intent, so transferring the liability from an action of intentional tort that actually results in a different tort action. So, if you intend to throw a punch at someone and you miss and you hit someone else, well, your intent from the first action is transferred to the actual consequence of your action and the third party. Transferring the liability from an intentional tort action against one person, not injured, to a third person that is actually harmed. There we go. Volition. Lack of volition must be absolute for you to be not liable for your the consequences of I guess the injury you caused. Gilbert and Stone, they threatened a person with murder unless that person trespassed, and the person trespassed, and that was voluntary despite the fact that someone was pointing a gun at them. So that is volition. They were exercising control over their physical actions. Now, whatever damages they're ordered to pay for the trespass, they could certainly turn around and sue the person who ordered them to do it at gunpoint. If you are carried onto someone else's land, then that is not voluntary and you are not liable. So lack of control is there's no volition, and lack of consciousness is also lack of volition. Capacity, children, they need the ability to understand and appreciate the consequences of their actions, and age isn't sufficient to excuse tort liability. It's tied to conduct. So were they old enough to understand the nature and quality of their conduct? So it's their age plus their conduct together, and you also compare that to a child of similar age and similar circumstances. So perhaps a child ran away from home at the age of 7 and has been living on the streets until the age of 10, and they do something illegal. Well, you can't compare them to a child who's been living with lots of support for their whole life. Children, parents are not vicariously liable unless they were a party to the conduct that caused the injury or they were found to be negligent. There are also parental responsibility acts in some jurisdictions which presumably would outline what a parent's responsibility actually is. So if your child injures someone, if it's on their property, they may be able to recover damages from the house insurance, but more than likely you're not going to get anything if the parents are not found negligent or were not party to the conduct, because the child wouldn't have any money. People with mental exceptionalities, they're criminally responsible if they can appreciate what it is exactly they're doing and they know it's wrong. They can be civilly responsible if they appreciate what it is they're actually doing, but they don't need to know it's wrong. So if they know they're punching someone, but think it's fine, they can be civilly responsible, but not criminally responsible. Motive. This is not relevant in intentional torts, except for when you are defending yourself against accusations of torts resulting from the writ of trespass on the case. So here, you can, I suppose, avoid aggravated and punitive damages if you had a beneficent motive. If your motive, which ended up causing this injury, was actually for a good purpose, then perhaps, you know, it's not an action that needs to be deterred. So defense of public necessity, establish that you are acting to protect the public interest from impending harm, and establishing the tort of malicious prosecution. So here, malicious is a motive. So in order to defend yourself against that, you would need to establish your motive. There are two considerations associated with motive. One is duress, and if you were under duress, then you can limit your the damages that you must pay. So when someone causes to do something by unlawful threats, it is, however, a defense in criminal law, but this is not going to make you immune from liability. Second, provocation. It must occur shortly after the injury. It's not a criminal defense, but it will affect damages in some tort actions. And this isn't a response to threat. This is a provocation of anger within you, and it's meant to reflect human infirmities or human fallibilities in the justice system. So this is how the fact that we can go a little crazy and get angry is mitigated within tort law. Mistake. When the defendant intends the consequence, but the consequences have different actual legal significance than they contemplated. So you intended to do something, but then it turns out to be a tort. Such the examples that we had in class where you intended to shoot that wolf, but it turned out to be a dog, which is someone's property, and so now you've killed their dog. Or you intended to cut down a tree and have it land right there, but then it turns out that that's your neighbor's yard. So, and this is, of course, not a defense in intentional tort liability. An accident is you did not intend to interfere with the other person. It was, your intention was not to interfere with them, and you weren't negligent either. So it was just a complete freak accident. For example, you're at a firing range where it's totally allowed to shoot a gun in the air, I don't know if it is or not, and your bullet goes up and comes down on someone's dog. Well, you know, you weren't shooting at the dog, so you weren't intending to hit the dog, and you weren't being negligent, though. Presumably there's no rule against shooting a gun in the air. So in any situation in which a person injures another person, but does so unintentionally without negligence, and there's no liability in this situation. So what the distinction between accident and mistake is that you didn't, you had no intent. Now there is the issue of foreseeability between mistake and intent, but I'm not sure where that fits in. Tort of battery. Battery is the act of violating someone else's bodily security. It's intended physical interference or actions that are substantially likely to result in physical interference, and it does not have to be harmful in order to be a tort of battery. Classic cases, Bettel versus Yim. The issue is whether or not someone who commits the tort of battery is liable for the unintended consequences of committing the battery. Yes, they absolutely are, unless the defendant can prove that their actions were unintentional and negligent, and not negligent, or establish a defense. torts derived from the writ of trespass. So, if the plaintiff can prove that they were directly interfered with, whether they were touched or punched or whatever, then the onus shifts to the defendant to prove that the interference wasn't intentional. Not that the harm wasn't intentional. They're responsible for the harm if there was interference, but that the interference wasn't intentional. And to prove that the interference wasn't the result of negligence. So the justification for liability for unintended consequences is that the tort of trespass is to protect the dignitary interests of people. And so the plaintiff should be able to recover all damages and not just those that were intended. They were innocent and the defendant is responsible for everything. With regards to assault, the intentional creation in the mind of another, a reasonable apprehension of immediate physical contact. So this is all about the impression that's created in the plaintiff's mind. If you call someone up and you are silent and you do this 3 or 4 times in a row, that could be assault because it's reasonable for the person to assume that they're in danger. If assault leads to battery, then assault is just kind of superficial and the court will mostly deal with battery. Raising the issue of assault can, however, provide the basis for defense of consent or self-defense. So if someone assaults you, that could be, assaults you in the tortious sense, that could help you in a defense of consent or self-defense, presumably, if you were battering each other. So, Holcomb and Whitaker, 1975, conditional threats, is it assault? Yes, it absolutely is an assault. You can't, force someone to choose between being battered and another option. You don't have that right. What if you make it clear that you have no present intention of carrying out your threats? Is it assault? According to common law, no, that is not assault. So, if I say, I can't really think of an example of this. When would you create in the mind of someone that they're in danger, but then say that you have no intention of carrying out your threats? I mean, that just seems ridiculous. What if you don't have the ability to carry out the threats? Is it assault? I don't know. I think it has to do with the impression created in the person's mind. So whether you have the ability to carry out the threats or not is going to be determined by the person who's scared. Great. That's what I learned in Torts week 1 of week 3.